Can I declare the meeting open to the public? I advise members that when in public session the committee meeting will be recorded and broadcast throughout Parliament buildings and online. And I advise members that those in the public gallery that they are welcome to use mobile devices as long as they are in airplane mode and all devices are muted. Attendees can also connect to the Assembly Wi-Fi and password details are available on the gallery rules. It is not permitted to take photographs or record any part of the meeting. Can I advise members that it is proposed that the oral evidence session with the Bar of Northern Ireland on the new clause 27A of the Justice Bill regarding taxation reform will be recorded by Hansard. So can I seek your agreement to that? Agreed?
Agreed, yeah.
Can I remind members then that they are obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence their approach to the matters under consideration? Any members who have interest to declare in relation to today's business should do so now or when the particular matter arises. Are there any interest to declare?
The usual access
just
to
the
justice,
membership of the all-party group on access to justice, which covers us all. Are members content with that? Patsy, you want to come in with another one? No? No, same one?
A declaration.
Okay, no other interest then? If not, we will proceed to agenda item number 3, which is draft minutes. Can I inform members that the minutes of the meeting held on Thursday 23rd of April 2026 are at pages 8 to 17 of the meeting pack? Can I ask members if they are content that the minutes are otherwise a true reflection of the proceedings at the meeting held on the 23rd of April 2026? And if so, I will sign. Members agreed?
Content?
You're content? Yep. Thank you. Okay, agenda item number 4 is matters arising. Can I ask members if there are any matters arising from the minutes that they wish to raise at this stage? No minutes or no matters, okay. So agenda item number 5 then is the Justice Bill Taxation Reform, new clause 27A, the Bar of Northern Ireland oral evidence. Can I refer members to pages 20 to 31 of the meeting pack for the relevant papers? Can I remind members that the Justice Minister intends to bring an amendment to insert a new clause 27A in the Justice Bill. The committee received the text of proposed new clause 27A in early March, but the timing meant that the committee had no opportunity to scrutinise it. Whilst the committee therefore did not take a position on this matter, members felt it would be helpful to hear from the Bar of Northern Ireland in advance of the consideration stage of the bill. The committee will also hear from the Law Society at next week's meeting. Can I inform members that the witnesses providing evidence today are Denise Kiley, I think.
That's right.
Oh, thank you. KC, Vice Chair of the Bar Council, Laura Vance, Family Bar Association, and David Mulholland, Bar of the Northern Ireland Chief Executive. You're very welcome to the committee. You're no strangers, of course, to the committee, and I'm sure you dip in religiously every week. So without further ado, if you have an opening statement to make.
Yes, Chair, members, thank you. I'd first like to extend thanks to the committee for hearing our oral evidence this afternoon. As you've said, Chair, my name's Denise Kiley and I'm Vice Chair of the Bar Council, and I'm joined to my left by Laura Vance, who is Vice Chair of the Family Bar Associations, and to my right, David Mulholland, who is the Chief Executive of our bar. We have submitted a detailed briefing paper, so thank you in advance for the time that you've taken to consider that. And this afternoon we intend to develop some key elements of that paper, and of course are happy to answer any questions that arise. As the Chair has said, this is our second time providing evidence on the Justice Bill. Members may recall that myself and David and the Chair of the Bar Council were here on the 6th of February 2025 to discuss Clause 28 of the Justice Bill. And you will know that Clause 27A of the Justice Bill is designed to replace Clause 28, which would have removed the role of the taxing master from the assessment of certain legally aided costs. The practical effect of Clause 27A is that when the taxing master is determining costs, they must now do so in line with the relevant fees, rates and arrangements set out in an as yet undrafted remuneration order dictated by the department. So whilst Clause 27A will retain a role for the taxing master, this will place significant limits on it. The Bar Council had previously expressed several concerns around Clause 28, you will recall, and while we're encouraged that Clause 28 will not proceed, we should state from the outset that the introduction of Clause 27A as an amendment to the Justice Bill does not negate all of our concerns. We continue to have significant concerns about Clause 27A, particularly in the wider context of the programme of reform of taxation now advanced by the Department of Justice. That context we think is important because Clause 27A is not being presented in isolation. It runs alongside the Enabling Access to Justice programme. However, the Department has not yet published the post-consultation report on the Enabling Access to Justice delivery plan, nor has it issued an updated delivery plan for the wider reform programme. And in the absence of those documents, it's not possible for us or for the committee to properly assess how the current proposals interact with other strands of proposed reform. This is particularly concerning given the recent decision of the Department to open what has been described as an engagement process, which proposes significant, some even radical reforms to eligibility, scope and operation of legally aided work in civil and family law matters, and I'll return to those shortly. This evolving and piecemeal approach has resulted, we say, in a lack of coherence across the reform agenda, making it difficult to assess the cumulative impact of the proposals, including costs, savings or unintended consequences. It has also led to uncertainty as to the precise policy objective. Initially, Clause 28 was introduced into the Justice Bill while separate reform was proposed through the Enabling Access to Justice programme, and that separate reform was proposed to be undertaken in a phased approach. However, the Department then departed from that position, suggesting that they would now approach taxation in a holistic way. And the Department's approach to reform of this important area has been marked by a number of such changes in direction. That has unfortunately created uncertainty and has limited the ability of us and other stakeholders to engage with and to respond to a stable and clearly defined proposal. We say that the questions that ought to be asked are, firstly, why is taxation reform being pursued by the Department? And secondly, what is the evidence base for reform in this area? Those are important foundational questions to which there ought to be clear and empirical answers. Regrettably, we think that the answers remain unclear. The Department has frequently said that its motivation for taxation reform is to improve transparency and accountability of legal aid expenditure, originally contending that the taxing master was independent and not accountable to the departmental accounting officer. That was the rationale that was offered for Clause 28. Later, the Department's evidence to the committee indicated that its position had shifted and that rather than removing the taxing master's power to order taxation of legal aid costs, its focus had moved to restricting the master's ability to set interlocutory fees and hourly rates. The rationale offered for that was that the 2025 increase to solicitors' hourly rates and interlocutory fees, which would create what departmental officials described as an additional and unforeseen budgetary pressure of £7 million on the department's budget. The Department has suggested that the increase to the solicitor's hourly rate and interlocutory fees was not foreseeable and that the process did not allow the Department to make contingency in its budget for the possibility that fees may be increased. Now, this committee has already heard evidence from Master Moore, the taxing master, and from the Lady Chief Justice on that increase and has heard about the robust, evidence-based, inclusive process that was applied to it. What actually happened was that the Department of Justice was in fact involved in no less than 7 meetings of a working group chaired by a High Court judge which examined the solicitor hourly rate and interlocutory fees across 2024 and 2025. So the Department had the ability to participate in the working group and to make representations just like any other stakeholder. As part of that process, the department's own January 2025 paper, which it submitted to the working group, explicitly acknowledged that it attended the working group because, and I quote, any rate set will impact on the legal aid fund. That same paper acknowledged that the department had received copies of the report on the solicitor's hourly rate, as well as the revised pleading and interlocutory fees from the bar as far back as the 27th of November 2024. And the department at that time stated that the purpose of its paper was to provide the working group with an assessment of the potential impact of proposed uplifts on the legal aid fund so that it could be informed of the potential repercussions of any decision to uplift fees and rates. So the department was not only aware of the possibility of an increase, but it actively assessed and presented the potential financial consequences of it before the taxing master's decision on the recommendations of the working group was made. It is therefore difficult to accept the department's later characterisation of the increase as unforeseen, considering its own prior participation and contribution to the working group process. The committee will also recall that in her evidence in January 2026, the Lady Chief Justice confirmed that the solicitor hourly rate and interlocutory fees had not been increased in 11 years. The bar's position is that it would have been reasonable for the department to anticipate and plan for an increase given such a period of stagnation. If the purpose of Clause 27A is budgetary control, then we say the department must explain how that is to be achieved in a system that is demand-led. Even if the department fixes an hourly rate, the time element of the calculation is going to remain variable if it's to be independently and properly assessed by the taxing master. So a time-based system may just alter the source of the unpredictability rather than removing it. A further and very important point that we urge you to consider is that of judicial independence. Through Clause 27A, the department is seeking to acquire the power to enact remuneration orders, essentially to set hourly rates for legal practitioners and to remove that power from the scope of the taxing master. As you know, the taxing master is an independent judicial office holder who can determine the hourly rate for solicitors and interlocutory fees for barristers. And in taxing a bill of costs, the taxing master is essentially independently reviewing and settling the amount to be paid for legal work. As the taxing master himself and the Lady Chief Justice both confirmed to this committee when they gave evidence in January, the taxing master already has a duty to the legal aid fund whenever carrying out that assessment. When the taxing master gave evidence, as he himself put it, he is there to protect the legal aid fund and to ask robust questions. So there is already a protection in the current system. And transferring that function of assessment from the judiciary to the department would represent a worrying encroachment on judicial independence. It would essentially place the determination of legal remuneration under direct departmental control. The significance of that cannot be overstated. To take that action would set a dangerous precedent whereby the Assembly would give consent to the department to curb judicial independence because a judicial office holder makes a decision that the department does not agree with. That's a point that we made previously in respect of Clause 28 and it remains in respect of the proposed Clause 27A. When it comes to Clause 27A specifically, another question that we urge you to ask is, what exactly is it that MLAs are being asked to vote in support of? We say that a satisfactory answer to that question hasn't been provided by the department. Effectively, MLAs are being asked to vote blind and to provide a legislative blank cheque for the department. Clause 27A, as drafted, provides no detail on the substance of these future remuneration orders. It says nothing about the framework for determining remuneration or the factors that will be considered. The committee will no doubt be familiar with the concept of skeleton legislation, and we've referred to this in our briefing paper, where key elements of policy are deferred to secondary legislation. The Delegated and Regulatory Reform Committee has made it clear that skeleton legislation should only be used in the most exceptional circumstances. And the reason for that is because it's at odds with the fundamental principles of parliamentary democracy. We can't understand that any exceptional circumstances exist here. Our concerns in this particular area are compounded by the timing of the amendment. We're aware that the committee only received sight of Clause 27A on the 3rd of March, around 3 weeks prior to the completion of the committee stage. That has seriously limited the opportunity for meaningful scrutiny, for stakeholder engagement, and for detailed consideration of the implications of the clause. The Bar Council, you won't be surprised to hear, advocates for evidence-based policy making, and reform of taxation has the potential to interfere with the ability of vulnerable people and their access to justice. It can involve sensitive, complex family cases or valid and urgent challenges to government policy, and therefore changes must be based on a thorough review of proven, contextualised and empirical data. In the past 2 years, in the context of fees relating to criminal legal aid, the Minister has repeatedly insisted that the change must be supported by verifiable evidence and that it must be data-driven. We don't see that same approach evident in the Department's proposals for taxation reform. The evidence base underpinning the proposed taxation reform lacks rigour. And progressing reform on this basis not only runs against the principle of evidence-based policy making, but runs contrary to the Department's own stated policy position in respect of criminal legal aid reform. More broadly, the reforms aren't based on any official statistics that are able to be analysed or broken down so that issues can be more clearly identified and appropriately addressed. It's essential, we say, that these proposed reforms are subject to rigorous due diligence, with all the relevant context and potential impacts being taken into account. That, regrettably, has not occurred. There has been no effective review to provide the evidential foundation for the wider reform of civil and family fees for publicly funded work, including taxation reform. And that is despite the Department's commitment in its post-consultation report, which it published in June 2025, where it committed to establish a civil legal aid working group to consider remuneration. As the committee knows, the Department established a fundamental review of criminal legal aid led by His Honour Judge Burgess, but there has not been an equivalent exercise in the civil and family context. So the evidence base for reform hasn't been established. And the issues that the Department would seek to address, transparency, proportionality, value for money, have not been properly examined in their context. So it's difficult to conclude, we say, that sufficient groundwork has been undertaken to support these proposed changes. And related to all of that, we say it's also important to understand that the Department's proposed taxation reform will apply to both family and civilly legal aided work. The Department is, it seems, attempting to apply a one-size-fits-all approach to different areas of law. That is too simplistic, it's uninformed, and it's a blunt approach. Looking back to 2025, the Justice Minister made a decision to apply the 16% fee uplift, which, as you know, had been recommended by Judge Burgess in the criminal context, to civil and family law also. That decision was said to be motivated by a desire to achieve equality between different practice areas. And in doing so, the Minister marked out the family bar as being dominated by female practitioners, while the criminal bar was mostly described as being dominated by males. And whilst the intention to approach matters equitably is welcome and is obviously a laudable one, it's hard to reconcile those actions with the fact that there's been no equivalent independent review into family legal aid in Northern Ireland. My colleagues in the Family Bar Association, including Laura, have made repeated calls for a fundamental review of the operation of publicly funded legal services and family matters. And the reason for that is because a fundamental review would present an opportunity to identify and address the systemic issues across the provision of publicly funded legal services, and to target reform measures in a strategic and evidence-based way. But unfortunately that hasn't happened, and instead what we've got is Clause 27A, which is the product of a disjointed programme of taxation reform, and it's foisted upon family and civil publicly funded services without that robust evidence-based, and also on the basis of shifting policy objectives, which I've already described. The Bar is also concerned that extending fixed fee structures to other areas of legal aid essentially risks replicating the undesirable situation where services are being lurched from crisis to crisis. We have seen that happen in criminal law. There is a risk that the department's approach will simply extend the access to justice crisis to the civil and family fronts. The Bar Council and this committee can't ignore the unfortunate reality that the department has a poor record of reviewing fees when they're required to do so, even whenever that requirement is a statutory one. The purpose of the requirement to review fees is to ensure that fees properly reflect the nature and complexity and the value of the work undertaken, and we've spoken about the reviews to this committee before. So for example, family care centre fees are dictated by the Civil Legal Services Remuneration Order 2015. The department has not fulfilled its statutory obligation to review those fees since 2015. Members are aware of the Crown Court fee levels that were due to be reviewed in 2018, 2021, 2022 in accordance with statutory obligations, but those reviews weren't completed. So those examples indicate a pattern of delay and a failure in fulfilling fee review obligations across different areas of legal aid remuneration. And it's often said that the most accurate predictor of future conduct is past conduct. And if that's the case, the department has proved itself incapable of fulfilling its obligations in existing areas of responsibility when it comes to reviewing rates of remuneration. And that being the case, the very last thing that this Assembly wants to be doing is giving it more responsibilities. Not only has the failure to review fees been a missed opportunity to ensure that they are properly reflective of the nature and complexity of work, it has also eroded the trust and confidence amongst the barrister profession and has reduced the viability of legal aid work and thereby occasioned risks to access to justice, which we have spoken about at length before. We wish to avoid extending that to the wider justice system, as I'm sure the committee would also wish to. Clause 27A would provide the department with expansive powers to set hourly rates at the expense of independent checks and balances, which are in place at present to ensure that the rates represent fair remuneration and that they're looked at regularly. And at this point, I would like to address the use of the brief fee, particularly as it relates to family fees and civil law matters. The effect of Clause 27A is that all fee claims would require to be assessed individually and to be paid on an hourly rate basis. The department has failed to explain whether alternative systems have been considered to hourly fees, which may include fixed fee models such as the Comerton scale or modifications to the current brief fee model, which has been in existence for some time. And again, we've provided some detail to this committee in the past about the brief fee. It, as you know, reflects a combination of risk and fair reward for a barrister. And by using individualised brief fees, a barrister with greater experience and skill who may be able to prepare a case in fewer hours would not be paid less than a barrister with less experience, whose skill might require longer to prepare, but who under hourly rates would ultimately claim more hours. There has been recent research in England and Wales, which we again refer to in our briefing paper, and that found that 54% of UK firms are expecting to increase the use of fixed fees and are moving away from traditional hourly rate building. The use of the brief fee also incentivises competition. It creates choice for instructing solicitors who can achieve efficient outcomes by selecting from a range of suitably experienced barristers. So the hourly rate model may realise unintended consequences of failing to reward experience and expertise, and that would be counterintuitive to the department's efforts to speed up justice. Over many years, the department itself has advised the profession that certain aspects of legal aid must operate on a swings and roundabouts basis. A brief fee, which entails some risk and incentive for the barrister, aligns with that philosophy. Comparative experience also shows that brief fees remain a recognised and retained model of barrister remuneration. In England and Wales, brief fees do continue to be used with the approval of the Bar Standards Board, which requires barristers to explain whether they charge by fixed fee, hourly rate or other arrangement in advance. Similarly, and again we have detail on this in our briefing paper, following its 2020 evidence-based advocate fee review, the Crown Prosecution Service in England retained and increased a range of brief fees for trial and guilty plea cases. So this evidence demonstrates that brief fees can support predictability, efficiency and administrative simplicity and should not be displaced without proper review. So we urge this committee to look beyond the headlines and sometimes oversimplified statistics about the costs of legal aid. Cases have become more complex. New and important legislation has been implemented and social and health issues are rising amongst the clients that we represent. The Bar Council is supportive of reform, but it must be the right reform at the right time, and it must always be based on a robust evidence base and a properly conducted consultation process. But it appears, unfortunately, that civil and family law matters can and have been relegated in the policy discourse. But those are matters that can involve constituents and individuals being at risk of losing custody of their children, their home, their reputation as a result of proceedings. So they are high stakes and they involve important issues. And the consequences of reform in these areas is stark. I've already mentioned the engagement process, which was launched by the department earlier this month, which proposes curbing access to justice through the removal of legal aid from the first stage, which you may also know is referred to as the leave stage of judicial review proceedings. That should be of great concern to anyone who is concerned with the ability of citizens to exercise their legal rights and to challenge public authorities and to ensure that they are making lawful and accountable decisions. And we will continue to engage with the department about these proposals, but you can see that this is not just about fees. These reforms create real issues about access to justice. And Clause 27A and wider access to justice reforms are not procedural matters. They don't have little consequence to this committee or to the Assembly. They don't just affect lawyers. They invoke real issues of access to justice for all of us and for your constituents. And they call for serious reflection on judicial independence and the importance of that in a democratic society. So we urge you to consider all those things. As I say, we're grateful that you have given us the opportunity to come today. I've covered a lot of ground here. I know we've covered a lot of ground in our briefing paper. So thank you for staying with me. And if you've got any questions for myself, Laura, David, we're more than happy to try and answer those.
Thank you, Denise. I'm going to go straight into it. Patsy, you're first up.
Thanks very much indeed, and thank you for your presentation. Just a number of things. You referred, there's two or three things that I would like to start off with. First of all, you referred to unintended consequences. Can you be specific about that to see what those might be? Because obviously you're the legal people, and you'll have handled these things. The other thing you did state was why is taxation reform being pursued and what's the evidence for it? And then there's reference made in your document to the Cumberton scale and fixed fees. It would be helpful if you could expand on that, please, and what the alternatives are, or if there are any alternatives. And you also stated that how cases have become more complex now. I'm kind of intrigued by that. Has it become more complex because they've been spun out a bit more, or become more complex because of maybe you could expand what you mean by that.
Start with that one, because it's all cases across all areas of law have become more complex, and it's not just about the time that they take, it's about the issues that are arising in those cases, and about the profile of our clients. There are a number of the clients that we now encounter have mental health issues, addiction issues, and that is becoming more prevalent, and that does add complexity to cases.
Maybe just add how that adds, just for me, I'm not a legal person, how that adds a complexity to it.
It adds complexity for barristers whenever we're meeting with our clients to try and ensure that we are explaining the issues correctly to people who have those potential difficulties, that we're getting the right experts involved, and that we're ensuring that those people can properly take part in court cases and the system. It's an issue that has prevalence particularly in the areas of family law and criminal law, so Laura may want to touch a little on it from the family law perspective. But it's not just that, there are also complexities arising in the technological aspects of cases, and we've spoken about this before when we've come to address the committee about criminal fees in particular and the complexities that arise in those cases. There are now technological complexities such as mobile telephone data. Those sorts of things didn't exist, and the need to analyse that, which appears in a lot of criminal cases now. Those things didn't exist whenever the fees were initially set for criminal cases. So it's technological advancements, but it's also complexities that we encounter in the population. As for your other question about the unintended consequences of taxation reform, one of the things that we have spoken about to this committee before in the context of other reforms such as the criminal legal aid reforms is a two-tier justice system, and that applies equally, and I suppose that's what we're getting at when we talk about unintended consequences, because this work will be unattractive to practitioners if it is not properly remunerated. And at the minute, what you have in front of you is a proposal to allow the department to have and impose remuneration orders without any detail on what those will entail. We don't know, it's not clear what the rationale behind that is, but it has been said that part of the rationale is budgetary management. And so if it is intended simply to be a reduction in the fees that the department pay, the work is going to become less attractive to barristers. There are all sorts of issues with hourly rate that we may come on to discuss, but it doesn't properly remunerate barristers for large areas of law, and it's not just as simplistic as setting down a rate and requiring a barrister to vouch for the work that they do in a case, but we'll maybe come on to hourly rate separately.
Well, I was going to come on to it anyway, so if I could just ask then further on that, if it ain't broke, why fix it? But you've already outlined there may be reasons to review it and to look at a system that has been in place for quite a while. Nobody's objecting to any of that, as long as it works better. Now, I looked in your papers and your briefing there, and thank you for it, about in England, Wales, how that's working, how the system's working over there. Just two elements to it. One is obviously the fees that we're talking about, but secondly is the efficiency of the system. How efficient is the system there as opposed to here? Because you clearly don't want to be introducing a mechanism here which is going to make things worse. But how efficient is the system over there?
I'll maybe make a few comments on that if I may. So, I mean, there definitely are backlogs and inefficiencies across all systems and all jurisdictions. But linking it to your question, Patsy, I think about unintended consequences. I suppose it seems strange that that the system might move to something that is based solely on a time-based system, because as Denise covered in her opening comments, you lose then the ability to reward and incentivise speed, to recognise experience, to encourage early resolution, because what you're setting up a system that actually measures and rewards the time taken rather than the outcome and the speed and the quality of that outcome. So it'd be fair to say there are different systems, different jurisdictions. Some of them are time-based, some of them are not. But this is one that, as we've said a few times, when it hasn't been reviewed, how do you know you found the right solution? And therefore the prospects, to your opening question, of unintended consequences have to be high in a system where you don't know actually you've diagnosed the problem. It's maybe a poor analogy, but it's like looking at Stormont and saying, overall Stormont is overspending, therefore each department needs to be cut by the same percentage. And that doesn't take account of need, the underlying drivers, the implications of that, the impact on who would be affected by that. And obviously a proper approach would be, before you propose a reform, you understand the problem.
One thing with your forbearance, Chair, and you've brought me into it there, thanks very much, David. You've reminded me, nudged me of it. Part of the argument would be devil's advocate here is, and you mentioned experience, and the higher levels and the more demand, usually the practitioners, you know yourselves, that there is for the more senior, more experienced counsel. How do then junior, less experienced, get that experience that's required and the remuneration for that?
I suppose if I can answer this in the context of family fees, and it brings us back to why we have asked for a widespread reform of all family fees. So what this clause does, it looks at one tier of court. So just to explain, in the family court, and this leads into the experience. So we have the family proceedings court, the family care centre and the high court. This bill only looks at the high court, so it's looking at one tier in isolation. But that is not how the family system works. That's not how a family barrister works, because often people work across all three tiers. So we say it makes no sense for the department to target one particular tier without looking at reform in respect of all areas of fees and how they sit amongst each other. So how is it sustainable for a family barrister to continue practicing in all tiers of court? So a younger barrister will start in the family proceedings court. Now, those fees were set in 1995 with the inception of the Children's Order. That is how old those fees are. Those fees have never been looked at by the department, and at this point are absolutely unsustainable for young practitioners. We then move into the family care centre, and those fees, while they were became legislation in 2015, those fees were actually set in 2009. Okay, that's how old those fees are. And again, it's only recently then the 16% has been applied as an uplift. And then we move into the High Court, and that is where then the taxation issue comes in. So what we say in the family bar is we need to look at how this impacts on practitioners across all tiers and all levels, from the very junior to the very senior. And it's very difficult to do that when the department have taken a piecemeal approach. We'll just look at one tier of court, but we'll not look at how that impacts the system. And I suppose, again, that leads on to the unintended consequences, and that is the real fear for the family bar. Because as you know, we represent the most vulnerable people in society. Nobody wants to find themselves in a family court. It's extremely difficult to navigate your way through. There are a plethora of issues. And what we want to ensure is that there are high quality representatives dealing with those cases who have experience, who have the skills, and we want to maintain that level of expertise. And what we're concerned about with reforms that have not been properly thought through, there's no evidence in respect of how this is going to look, how this is going to work. And we worry that that work will become unsustainable from junior members right up to senior members, and people will start looking for work in other areas. And we simply don't want that to happen. People deserve proper, good quality representation by family barristers, and we feel it is really important that that is maintained. And we worry that this really is ill thought out. We don't know the consequences. We're not scared of reform, and that is why we've come forward on many occasions and said, absolutely, but we need to look at the system as a whole.
Okay, thank you.
Okay, Brian?
Okay, thank you for your attendance and for your paper. So I'm still thinking this through, and it seems like there's almost like certain principles being applied here. First of all, is accountability for public funds, and we believe in that. Obviously, that is our role, to ensure good value for the public purse and that all public funds are well spent. You refer in your paper to reports by the Public Accounts Committee and Northern Ireland Audit Office in 2016. Well, you say that the department is using that to justify their proposals. Can you clarify what was in those reports? Was it something like this, that the department should set rates?
I don't think it was quite as express as that. I think there were more general recommendations about accountability. But this is one of our difficulties with the evidence base, that it's not clear how these reforms are at all fours with the recommendations. And we also say that those recommendations were made, as you've pointed out, in 2015, 11 years ago, and the department haven't looked at this since. A lot has happened in the justice system, as in all areas of life, in that 11-year period. So it's not as simplistic as simply just implementing a recommendation. So I don't think it's the case that any of those reports suggested what the department is proposing now explicitly. But equally, there has been a passage of time that the department need to look at what the realities of the justice system are 11 years after that report, and that simply hasn't been done.
Yeah. And we're all aware of all the disputes over rates, and you've referred to rates being set in 1995, and I'm not sure, did you say that those recently did increase?
The 16%.
The 16%.
And that came about as the Burgess review into criminal cases, and the department simply took that figure of 16% and applied it to family. There was no reasoning behind that. There was no looking at family fees and whether that 16% was accurate or correct. And again, that's why we say that this needs to be looked at as widespread reform.
Okay, the second issue is sort of separation of the legislature and the judiciary. So you sort of pointed towards that. 2.6, judicial independence. You're saying this, transferring the function from the judiciary to the department would represent a clear encroachment on judicial independence by placing the determination of legal remuneration under direct departmental control. So I'm just wondering how true is that? Is that really challenging judicial independence if the department is setting rates, for services delivered by barristers? It's not impacting on how they undertake their function, in interpreting legislation, and make legal rulings.
There's a couple of elements to that. The first is that it seems that at least part of the motivation that the department has offered for this reform is the recommendation of the taxing master in respect of the uplift of interlocutor fees and the solicitor's rate, which I described earlier. The department had described that as an unforeseen budgetary pressure. And so the concept of judicial independence bites there, because it appears that the part of the motivation behind this is because the department don't like that decision and are taking this step in order to try and take back control in respect of a situation that they don't like, in respect of a decision that an independent judicial officer has made. So that engages judicial independence.
So do you mean the taxing master, or who do you mean?
The taxing master,
right,
exactly. Yeah. And the taxing master is an independent judicial officer. And the other element is that the taxing master has already confirmed to this committee, as is the Lady Chief Justice, that protections already exist within the system. The taxing master has a duty to the fund. And one of our difficulties with the department's proposal is they haven't explained what their difficulty with the current system is. They haven't explained what the problem is that needs to be fixed. And so that it is a worry that these proposals would try and take power back from an independent judicial officer and bring it in-house to the department. And that is an encroachment on judicial independence, because the proposal would significantly stunt the powers of the taxing master. It would still give him some powers under 27A, but it stunts them, and that does interfere with judicial independence.
Right. Well, that's the third point, and you sort of framed it around access to justice, and ensuring that barristers, similar to other lines of work, dentists and so on, where we hear, if NHS dentistry isn't paid at the right rate, the dentists just aren't taking up that work. So similar concern, you're saying that barristers would end up not taking up certain work if remuneration is not there, or solicitors. So the way it currently works, does the taxing master have a scale that they apply? I mean, how much control is there on what rates they set? My reading of this is the department is just going to set like an hourly rate, and I appreciate you're agreed that it's unknown at this stage, that you don't know what the scale would be, what the rate would be. But what the taxing master will still have a role in determining the final amount. Is that correct?
No,
under
our
the proposals?
understanding is...
And sorry, my other question is, does the taxing master currently use a rate?
Yeah. Well, our understanding is that the taxing master's role would be reduced simply to calculating the appropriate number of hours. So the value would be set, and the taxing master's role would be reduced to calculating that. That gives rise to real concerns, because that is a significant reduction in the taxing master's role, and it does bind him significantly as to what he can do. In respect of the second question, different areas of law have different issues. There are scales that do exist in different areas of law. So we refer to the Comerton scale, for example, that exists in civil law. Those are rates that are set, that essentially set fixed suggested fees on a scale for particular types of work. But the other element of what the taxing master does, they don't apply in everything. They apply in civil law, but there are other elements of law that there is no scale, but what the taxing master does is set out to try and come at a reasonable fee. The taxing master is legally qualified and has experience of working in these cases. So a barrister submits their bill to the taxing master with justification for it and an explanation of what it entails, and then the taxing master, applying his experience and expertise and analysis of what was undertaken, arrives at what is considered to be a reasonable fee.
And as it currently operates, he would have different scales for different complexity of work?
There aren't fixed scales in all areas. But complexity is certainly a factor that the taxing master takes into account. But there aren't set scales in all areas yet. But one of the things that we say in our paper and in my remarks is that one of the issues we have with this proposal is that the department hasn't asked us about any of that yet, and that the proposal assumes already that brief fees are gone and that hourly rates would be imposed, and that is a significant change to the way costs are dealt with in Northern Ireland.
What are brief fees?
Brief fees are the fixed fees that barristers mark in certain areas where, for example, those scales don't exist, and the brief fee is a fixed fee which takes into account not only the time spent on a case, but the complexity, the importance of the case. But that system has been in existence in Northern Ireland for a very long period of time, and part of our difficulty is that the proposal and our discussion about hourly rates has been made without even engaging with us about the alternatives to moving to an hourly rate, and whether there could be amendments to the current system that might satisfy the department's concerns, but that hasn't been consulted upon.
And even in the current system, as it applies to family law and the Family Proceedings Court and the Family Care Centre, that does work on a system of brief fees, and there's no suggestion that would move to an hourly rate. So it's hard to rationalise why on a different tier of court then such a different approach is being taken. And again, it's back to the point that we have no evidence to support that will work or what that will look like. The department hasn't given us that information about why an hourly rate has been suggested. And these fees have been looked at before in terms of taxation. There was a considerable amount of work done in 2015, 2016 around the brief fee and about proposals for scale fees. That was abandoned by the department and has never been picked up again. So again, we say there are alternatives to this model, but those need to be looked at, and we need to look at what the effect is. The hourly rate has really, for us, come from nowhere, and it's such a shift in the current system, and also a shift from the different court tiers that it's hard to rationalise why it would be applied to one court tier when brief fees are used in other court tiers.
Mm-hmm. I mean, 27A seems very brief. Well, I'll speak for myself. I had difficulty understanding 28. But it seems a lot of it, I can accept your frustration that a lot of it is remains unknown what actually it'll mean in practicality, and you might end up with just again in a negotiation stroke dispute with the department on the actual practical amounts.
And it's about more than that too. It is about the wider reform to taxation. If the department has proposals to make about wider taxation reform, it makes sense to propose that as a package so that we and you and all stakeholders can understand the proper impacts of it. But we are concerned that this clause is being proposed, and it may on the face of it not look like a clause of much significance, but if it is passed, it does have significance, and it means that you're doing something to give the department the power to make remuneration orders that could have a huge impact on consequence that we're not aware of yet because the department hasn't properly assessed them.
And just on your point then about the negotiations, what we want to avoid is a situation where we lurch from crisis to crisis, and we see that has happened in the criminal bar. The family bar we have worked hard to maintain the system under the current fees, even though very poorly remunerated in some court systems. But we don't want to be in a situation now where we have to lurch from crisis to crisis. We want to be in court dealing with these cases for our clients, and that is why it's so important that we get this right now. Instead of allowing the department to simply have the power to enact whatever fees they feel are appropriate. And given the lack of reform to date, we do lack confidence in the department and their willingness to negotiate with us.
Okay, no, it's not just the confusion around the text of 27A and 28, it was the confusion around whether we were keeping 28 and this was a new fresh amendment, and then it transpired then no, that was a replacement for 28, so there was that confusion for months. Ciara?
And to be honest, it's more comments and maybe one overall final question. As you're aware, I have asked and continue to ask on numerous occasions when officials were in here a year ago on this very issue. We're not clear in relation to accountability, transparency versus budget. I'm not clear whatsoever because we've got skeleton legislation. It's quite clear that it hasn't been contextualised as to why we're doing it in the first place. I haven't seen any empirical data. We don't know what the fees would look like, how the fees would be set, what's the plan for it. It's just really blunt. And I know even in meeting with the taxing master a few months back, he wasn't even aware what his role would be, how it would change. And I'm really concerned about a move to fixed fees and what the impact that would be on cases, and particularly not only the profession, but likewise access to good quality service for all, and particularly vulnerable people in accessing. And likewise, even competition. Value for money, what does it do for that? So there's so many unanswered questions, and then the stark lack of consultation. So for something that supposedly to improve accountability, transparency, this whole process has had no accountability or transparency. So I've been very vocal on that from the start, and I'm gravely concerned. Glad 28's gone, but for 27A it's not making really any difference. And then how this ties in, as you say, with the whole enabling access to justice system, which should be over, so we don't even see the whole picture to be able to understand the intricacies of smaller pieces of legislation to how to improve access to justice. So it's just a total lack of coherence altogether in this. So I don't know why it's been pursued, and I still don't. And I don't know where the evidence base is to tell me elsewhere. So that's where I sit at the minute, and I still haven't been convinced, even though I've asked officials when they've come in here a couple of times why they're doing it, what's it going to look like, what's the context for it. I haven't been satisfied with any answers. That's my position. So really just general, given that, do you accept the need for legislative reform of the taxation process, or in your opinion, is the role of the taxing master as it stands should be maintained in this current circumstance?
We can't accept that there is a need for reform because it hasn't been shown to us. We haven't seen any evidence because the department hasn't put it out there. And as I've referred to a number of times, if, for example, trying our best to identify the rationale behind it, if the rationale is more budgetary accountability or accountability and transparency, then protections already exist within the system. That has been confirmed. The taxing master has a duty to the public fund. There is already accountability and transparency there. If there is a particular issue that the department wish to change and that they're unhappy with and they want to target reform in that area, then they should come with evidence to support that, and reform should be targeted. But as it stands, the department hasn't identified an ill in the system that must be corrected. And just to go back to your point about the coherence of reform, it's not just about what is in front of the committee now, it's about how we got here, because there have been shifting sands. In December 24, the Minister came out and proposed a phased reform, and said that reform would first be in relation to High Court and bails, and then in relation to Criminal Court of Appeal cases, and then civil cases. And she set out steps and promised consultation in respect of each of those steps. So that hasn't occurred. The policy position has shifted, but the promised consultation hasn't occurred either. So it's very difficult to respond. But as a general proposition, we don't see that there has been an ill identified by the department that has to be corrected. But we are open to discussions. We are willing to consult. If the department want to consult with us on them, we will have open discussions with them about it.
And have they contacted you in relation to the consult on?
Yes,
27A?
they have. They met with us relatively recently to tell us about 27A, and we did express obviously how we would want to have close engagement consultation to move this on. We have asked some questions of them, and they have provided the answers that they're able to provide right now. But I think we would all accept, and I would be confident the department would accept, we have a long way to go in really understanding A, the current problem, and therefore B, designing the right solution.
And I think in terms of we did meet with them to talk about 27A, but it was only following then we discovered the enabling access to justice reforms that were being proposed, and I was disappointed in that we didn't receive both at once, because they aren't standalone. It's how it impacts in the system as a whole, and to be delivered one day and then to discover that actually there were further reforms and to not understand how they sit with each other or what the thinking is behind those. And again, it's just being dealt with in a piecemeal way, and we say you can't approach it in that way.
I know we shouldn't speculate about things going wrong, but let's say in a couple of years there isn't the family legal system or the judicial review system that we currently have today. As MLAs, I'm sorry to warn you that the issues will present themselves at your offices about families who no longer can access the family justice system or who have a legitimate challenge to government, but the opportunity to take that through a judicial review has gone. I'm not scaremongering. LASPO, when it happened in England and Wales, had exactly that effect, and constituency MPs were swamped by those kinds of issues and couldn't cope.
Connie?
Yeah, thank you. Thanks for coming in today and for your submissions. I'm just going to clarify because I'm a bit confused. So you're concerned, obviously, you've put forward the lack of consultation, but you have met with the department on this?
Mm-hmm.
Okay, and you met with them once about 27A, or how many times have you met with them?
We've met with them once, but there isn't a live consultation. It was a meeting just to discuss what they had in mind.
And was 27A discussed in, I understand there is a working group that's been established to look at the solicitor's hourly rate and barristers' interlocutory fees. Was this raised at that?
No.
27A wasn't the
No,
proposal at that
wasn't
time. It
it?
was clause 28 at that time.
At that time, okay. That's no problem, just for my own clarification. I wanted to talk as well about my understanding, and like correct me if I'm wrong, from 27A, is it does look as if it's trying to bring us into line on some of what happens in England, and that the rates are set by the Ministry of Justice, but obviously they have quite a different legal system with us, where they don't have a taxing master. Can I get your opinion on that, and whether you think how that system works, and if you think that's what this looks like it's trying to do?
We think that they have looked at other jurisdictions, and what is proposed has some similarities. However, in England and Wales, the proposals to extend the use of, the reduction in the powers of the tax master have been halted because they've met with an unfavourable reaction and predictions about further problems that will arise from that. So I don't know that the situation in England and Wales is as stable as we might want. And each jurisdiction has a different approach to this. That all being said, the needs of the legal aid system in Northern Ireland need to cater for Northern Ireland, and can't be taken to be an analogue to exactly what happens in England and Wales. And as you've acknowledged, there are differences in the systems.
Mm-hmm. Look, we do need to ensure oversight of public money, but also ensuring fair remuneration for the legal profession, but also ensuring access to justice. And I am particularly concerned about family law and the family courts. I talk to a lot of my constituents going through that process, and a lot of them are vulnerable, and there's often children at the heart of it. And it is very difficult. We don't have infinite resource here. But something I did want to ask is if you could just actually explain from my own knowledge how the brief fee currently works and how that's submitted by barristers and the workings out around that.
I can certainly answer this in the context of family cases. So at the end of a case, we have to do a very lengthy and significant report to the taxing master to set out what the case involved, okay? And
Is that every case?
Every case.
Right, okay.
Every case. So every case has an individual report, and that is a very extensive piece of work in which we set out exactly what was involved in the case, how that was broken down, the issues, vulnerabilities of clients, outcome of the case, and then we set out all the work done in the case. And that report then goes to the taxing master along with, he will have a file of papers including all the court orders, so everything that happened in the case. He will read the report and then assess whether he agrees that that is a fair fee, or whether he feels that the fee should be reduced. And then he will set out his reasons and justification for that. So that's how the process works. And it is that independence and judicial oversight that we say is the appropriate system and has been working. And again, as Denise has pointed out, that the department have never been able to tell us why that they say that that is not working.
Okay. And then so you have to produce this brief for every single case. That obviously is quite a burden on you. And then how is 27A, is that going to negatively impact that?
Well, it would work, and I suppose this is the difficulty because we don't know really what the department are proposing. We've been told hourly rates, we haven't been told any more than that, but it is a considerable shift away from the way we work. For example, firms that use time recording would have time recording systems and would record billable hours. That is not how we work, it would be extremely onerous on practitioners. Often then we work antisocial hours. So in a context of a family case, families in the court system often move from crisis to crisis as things happen. A case isn't static. You get one set of facts at the start, and as the situation evolves, different problems occur for that family. These can occur often late at night. They can often occur in a crisis, and barristers and solicitors will be expected to down tools and deal with that particular crisis. So there's no thought from the department about how we would look at antisocial working. And again, that all comes back to sustainability, because this work has to be, attractive to professionals to keep doing it, and ensure that those clients get a high quality service. And we simply have just a dearth of information about what that would look like and how it would impact on individual fees.
And just to add to that, we have previously provided a paper to the committee about the brief fees, which we can provide again if it would be useful. But one of the things about a brief fee is that it is capable of encompassing components which reflect the complexity of a case, the importance of a case. It's not just about your time spent. It can reflect those elements such as the urgency and the particular factors involved and vulnerabilities and the importance of it for the individuals, but sometimes in wider public cases for the wider public too, because a decision in one case may have implications and may set the law for other cases. So a brief fee is capable of taking into account and encompassing those things. An hourly rate fee is a blunt instrument. It really values form over substance. So it's about time that you've put in rather than the value and the quality of the product that you get out. So it's not simply just about replacing one thing for another. It's not the case that an hourly rate can simply just step in and it might result in a change of the way we work, or it might just require us to time record. It's a fundamental shift in the way that barristers get paid, and that's why we say it's such a significant change that it really needs to be more carefully thought out than it has been.
No, I appreciate you explaining that. And just last question, Chair, if that's okay. Look, I appreciate that you've come to tell us that you don't really accept the need for reform and that you feel that hasn't been provided to you by the department. But I do acknowledge that you've said you would be willing to look at alternatives. Is there any alternatives that you had in mind that you'd like to provide with the committee today, or anything that you think would work that you would be like to discuss with the department?
Well, I think, we've referred to some potential alternatives in a broad form in our paper, and that's all that we can do at the moment because we don't properly understand the rationale. So as David put it, it's hard to understand the solution if you don't know what it is that is trying to be fixed. But in very broad terms, there are other tools out there. For example, the Comerton scale that we've already discussed. For example, potential tweaks to the brief fee and requirements to estimate that. There are potentially things that can be done, but we're at the very early stages of considering that because we haven't been asked specifically about it by the department. So yes, we are willing to discuss it, and yes, there may be things that can be done, but at the minute, without really understanding the purpose behind this reform, we can't propose coherent solutions.
I think that's it. It's to come up with a solution when we don't know what the problem is, and that's what we've repeatedly asked the department, what is the problem? And I say we're not close to looking at that, but if they can identify what it is they're trying to fix, then we can turn our minds to consultation about that.
Thank you.
Okay, can I just ask, it's my opinion that 27A really only materialised whenever there was a 7 million pressure added to the budget. So that's my understanding, is it's that pressure that basically motivated 27A, notwithstanding what the Minister was going to do with 28. Is that your understanding?
It's that, and I suppose then as Denise had referenced earlier, the working group and the interlocutory fees, and then the change to the solicitor's hourly rate, and in many ways it was almost a knee-jerk reaction to that, and that's our only real understanding of where it came from.
And if that is the motivation, this is not the solution, because as we have said, an hourly rate doesn't provide predictability. So if what is required is predictability, the hourly rate is not necessarily a solution for that. It might just shift unpredictability to a different place. So if that was a rationale that was properly articulated to us, we might be able to turn our minds to thinking about potential tweaks to the current system. But certainly it does seem that is the motivation. Certainly the timing would suggest that. And we're all at a disadvantage because of the timing of this proposal. But it does seem that that's a major factor. And if it is, the hourly rate is not the solution.
Okay, Brian, you want in for a small?
Yeah.
I don't want to go around the houses again.
No, indeed. Well, look, I always like to test my own understanding. So 27A is very brief. So I'm just wondering how much of what you're saying is speculation, or do you have grounds, like when you talk about an hourly rate? So, I mean, my reading this, an order under paragraph 3 may include provision about how any person who, in accordance with the orders to determine the amount of remuneration, that's the taxing master, I presume, may or may not determine that amount in any case. So it's just giving, currently the taxing master is independent of the department.
Yes.
And this is just saying the department can issue an order, is that right? So like some restrictions or some guidance. It says may or must, which seems, even understanding that. But so when you talk about an hourly rate, obviously that's not specified here.
It's not specified in the legislation before you, but that's what we understand that the department intend.
Right. They've indicated that to you.
And the remuneration orders, yes, would restrict what the taxing master could do, because if a remuneration order existed that set hourly rates, for example, for certain types of work, then the taxing master's role would essentially be reduced to calculating whether the hours marked are reasonable hours. That's the only foreseeable role that he could have.
I think maybe a question to ask would be, if the Justice Bill wasn't going through at the moment, would 27A be there at all, or would instead the department do it in the sequence we're recommending, which is build the evidence base, identify the problem, and then legislate for it? Yeah. But the if you like, legislation is part of the difficulty, and unfortunately it pulls you into speculation then. But certainly, to answer your question, the department has indicated that the proposed model would be one of hourly rates. Yeah.
Right. We quite often see this legislation, which is like an enabling power, and it just gives a power which can then be exercised, but you're in the dark, but you've strong suspicions.
Okay, I'm going to leave it there. Thank you very much for your time here today. It was a marathon session there. We're struggling for time, so thank you. Thank you very much.
Thank you all.
Okay, moving on then, members. Agenda item number 6, Criminal Justice Sentencing, etc. Bill. Written papers, 6.1, the Clerk's memo. Can I inform members that the Clerk has prepared a memo at pages 33 to 36 of the meeting pack, which provides an update on the committee's call for evidence on the sentencing bill. The call for evidence is currently due to finish on the 8th of May 2026, and so far 10 responses have been submitted via Citizens Base, and a number of other responses have been received by email. 3 organisations have asked for extensions on their submissions beyond the 8th of May to the 22nd of May. In view of the number of responses so far and the extension requests, members may wish to extend the final submission deadline on the call for evidence for 2 weeks to the 22nd of May. So can I ask members if they're content that closing date for the call for evidence be extended to the 22nd of May 2026? Agreed. Can I inform members that although it is not normal practice for oral evidence to be taken prior to the call of evidence closing, members may wish to consider if there are key stakeholders that the committee knows at this point it will wish to hear from on the provisions of the bill. Details of stakeholders that the committee may wish to invite at this stage are included in the Clerk's memo. Can I ask members if there are stakeholders that they wish to schedule oral evidence with at this point to ensure that the evidence sessions can begin promptly following closure of the call for evidence? Can I get a page number for that list?
34.
34 members. So if we can go to 34, are members content with that list? PPS, Probation Board, Police Service and Human Rights Commission. Okay. Members content?
Yeah.
We also had committed, we agreed to consider hearing from the following: Marie Collins Foundation, Jim Gamble and the Commissioner for Older People. Are members content
No issue.
with that?
Yeah.
Okay. Can I advise members that the Commissioner designate for Victims in Crime Northern Ireland has also offered to facilitate informal meetings or small events to allow the committee to hear directly from victims of crime. So can I ask members if they're content for the clerk to liaise with the Commissioner designate to explore a proposed approach to informal meetings that would enable the committee to hear directly from victims of crime on the provisions of the bill in an appropriate setting? Members agreed?
That's a really great idea. If
Yeah.
it can be done in a sensitive, appropriate way, I think that's really good.
Okay. Thank you, Connie. And can I then finally inform members that the clerk's memo also outlines a number of matters not currently within the bill, but that the committee has been asked to consider as part of its scrutiny of the legislation. It is possible that additional matters may also be raised before the call of evidence closes, and that the committee then need to consider how it approaches these issues. So again, can I ask members if they are content to note the additional matters at this stage? Okay. 6.2 then, the Northern Ireland Policing Board response to call for evidence. Can I inform members that the committee has received a response from the Chair of the Policing Board at page 37 of the meeting pack to advise the committee on the Policing Board's views on a number of provisions within the sentencing bill. The Board welcomes the bill's provisions on assaults and attacks on public service workers and supports the position that the new offence and statutory aggravator should apply to all those workers assaulted while providing a public service, providing services to the public or performing a public duty. The Board also notes that the bill gives consideration to sentencing charges on a number of serious road traffic offences and believes it is important that the deterrent for these most serious offences reflects a devastating consequences for such incidents. So can I ask members if they're content to note the paper or if any further information or clarification is required at this time? Members content? 6.3 then, Retail NI response. I can refer members to page 38, which contains a submission in response to the sentencing bill from Retail NI. Can I inform members that Retail NI welcomes the progress that has been made with regards to broader public worker designation in the bill, but feels there is still work to be done to ensure the protections which other regions have accepted that are retail specific are introduced in Northern Ireland, and highlights recommendations it has previously made for tackling crime against businesses. So Retail NI have also stated that they would be delighted to provide oral evidence to the committee as part of its scrutiny of the sentencing bill. So can I ask members if they're content to note the paper and to consider further when planning additional oral evidence sessions after the call for evidence is closed? Members agree? 6.4 Committee for Infrastructure response to call. Refer members to page 41, which contains a nil response from the Committee for the Infrastructure. So can I ask members if they're content to note? Okay, agenda item number 7 is SL1 Special Educational Needs and Disability Tribunal Amendment Regulations Northern Ireland 2026. Can I refer members to pages 42 of for the relevant papers? Can I inform members that the Department of Justice proposes to make a statutory rule under powers conferred by the Education Northern Ireland Order 1996 and the Special Educational Needs and Disability Northern Ireland Order 2005. The rule will amend the Special Educational Needs Regulations Northern Ireland 2005 to allow for reform of the Special Education Needs and Disability Tribunal, to introduce new processes for mediation in disputes and new rights of appeal. Some of us, I know, dip into this work on a yearly basis. The rule will be subject to negative resolution procedure, and it is proposed that the rule will come into operation the 1st of September 26. So can I advise members that in line with the new processes for delegated legislation, the committee is asked to agree: 1. Issue a call for views on the proposed statutory rule using the standard survey. Publish the SL1, the Appendix A and the draft copy of the proposed statutory rule on the committee's website. And then lastly, consider the proposed statutory rule at the meeting on the 21st of May 2026. So can I ask members if they're content with these arrangements? Content? Can I seek members' agreement to request the views of the Committee for Education on the proposed statutory rule, given its relevance to the remit of the Department of Education? Can I also suggest that we write to the Department too, just to ask if they have any views? Members content? Okay, agenda item number 8 then is review of State Pathologist Department of Justice written paper. Can I refer members to page 71? Can I inform members that the Department of Justice has provided the committee with a copy of an independent review report to the State Pathologist Department and the Department of Justice and State Pathologist joint response to the recommendations contained in that report? Can I inform members that the independent review report was submitted in November 2025 and made 25 recommendations to the Department and State Pathologist? The joint response has accepted 17 of the recommendations and 6 have been accepted in principle. 1 recommendation has been partially accepted and the remaining recommendation requires further consideration. The Department's update also indicates that it is working in conjunction with the State Pathologist Department to progress each of the recommendations, and the Department will keep the committee updated on its work in due course. So can I ask members if they're content to note the paper or if any further information or clarification is required at this time? Yeah, Emma?
The only thing, I know that there, and thankfully it's not an issue that I have dealt with as a constituency MLA, but I know that there are problems with a lack of pathologists for children and parents having to travel, I think, to Liverpool. And I know that that is something that there were calls upon the Minister to work on that before. Probably at the beginning of this mandate, I think is the last time it was raised, in line with the baby loss certificate scheme that I know is underway. So perhaps if there was something that we could go back to them to ask about that specifically.
Yeah, we can. Can I also say that this has been raised before and we have written. They say they've accepted 17 of the recommendations and then they say they've accepted 6. 6 have been accepted in principle. So what is the difference? What does it mean when you accept 17 but then accept 6 in an principle stance as opposed to just accepting them? So maybe we could go back and ask them exactly what they mean by that phrase, because it seems to occur quite a lot when they talk about in principle. Does that mean they accept it but they're not going to do it? You know, I just don't know. Okay, moving on then. Agenda item number 9, correspondence. Can I inform members that there is a correspondence memo and 12 items of correspondence at page 156 to 305 of the meeting pack? Can I advise members that I will draw their attention to 6 items and then members will have the opportunity to raise other issues. 9.3, can I refer members to page 162 of the meeting pack? Can I remind members that at its meeting on the 12th of March, members agreed to forward to the Department of Justice correspondence on a number of questions for response that the committee had received from an individual regarding the Police Injury and Duty Scheme and the Committee of Justice oversight of its review. Can I inform members that a response from the Department has now been received? So can I seek members' agreement to forward the Department's response to the individual who has raised the matter with the committee and to advise that the committee has noted that the review is ongoing? Agreed. 9.4 then, can I inform members that in related to the previous item of correspondence, the committee has received a number of further questions on injury on duty awards from the same individual, specifically related to the withdrawal of joint medical guidance for such awards. This is in response to earlier correspondence from the Policing Board, which was forwarded to the individual on the 17th of April. So can I seek members' agreement to forward the individual's latest questions to the Department of Justice and to the Policing Board for a response? Agreed. 9.5 then, can I refer members to page 173 of the meeting pack, which I can inform members that, again, related to the previous 2 items, clarification has been sought on the committee's power to scrutinise both the Northern Ireland Policing Board and the Department of Justice. The correspondence outlines a number of specific areas that the individual would like clarity on in relation to the committee's powers and scrutiny of the Policing Board and the Department. So can I seek members' views on how they would wish to proceed? Can I maybe suggest that we send back and advise the individual of the standing orders and the remit of the statutory committees and its powers and responsibilities? Is that okay? So that would be Standing Order 48.2 and then paragraph 9 of Strand 1, and then we can allude to the section 44 of the Northern Ireland Act 1998 and the power to call for witnesses and documents. We'll just copy that off and send it to him. Are members agreed?
Yep.
Okay, thank you. 9.6, refer members to page 175 of the meeting pack. Can I remind members that at its meeting on the 12th of March, the committee agreed to write to the Secretary of State to express its concerns about the apparent unfairness outcome for some individuals who had made applications to the Troubles Permanent Disablement Payment Scheme and the role of the Victims Payments Board. The committee requested clarification from the Secretary of State on what consideration had been or will be given to amending the 2020 regulations to deal with such unintended consequences. Can I inform members that the committee has now received a response from the Secretary of State in which he has advised that there is an appeal mechanism built into the scheme delivered by the Victims Payment Board, and that, in his interpretation, the committee's concerns relate not to specific amendments of the regulations but with the implementation of the scheme, which is a matter for the Executive Office. So can I seek members' views on the response and any further action the committee may wish to take on this matter? Can I seek members' agreement to maybe forward the response to the Executive Office for their response? Are members content?
Yeah, happy enough.
9.7 then, can I inform members that, again related to the Victims Payment Board, the committee has recently received correspondence from an individual raising concerns about the Victims Payment Board and decisions being on claims to the Troubles Permanent Disablement Payment Scheme. Can I remind members that it was agreed at last week's meeting to defer consideration of this correspondence until this week, when members have had a chance to consider it in the context of the Secretary of State's response on the scheme. So can I seek members' views on the correspondence and any further action the committee may wish to take on the matter? Can I maybe suggest that we send him, this individual, the Secretary of State's response and our letter to the Secretary of State to give him some context, and say that we have been, engaged in this? Is that okay? Members agreed? 9.9 then, can I refer members to page 222 of the meeting pack? Can I inform members that the Committee for Finance has written to all statutory committees to seek views on the Marriage and Civil Partnership Bill, which is now at committee stage. The Finance Committee has asked for a response by noon on the 9th of June. Can I seek members' agreement to respond to the Finance Committee with a nil response? And then can I also...
Sure.
Sorry,
just
go
to
ahead.
declare I'm a member of the Finance Committee.
You're on the Finance Committee?
Yeah.
Oh. Bear with me 1 wee minute. Yeah. So also then item 9.11 at page 294. Can I remind members that the committee agreed last week that it was not necessary to receive copies of correspondence that were identical to those in the pack. This is a current theme. This item has been included as it is different to previous correspondence. However, the number of further items have been received which relate to the specific case. But these are copies of correspondence that were issued to other individuals. I've been getting them too as a personal MLA too. I'm not sure if you guys have been copied in. But can I ask members if they're content that any items relating to this case that the committee has been copied into but are not in any way connected to are not included in the meeting pack? Are members agreed?
Agreed.
Yeah. Okay, thank you. So can I ask members if they're content to note the other items of correspondence set out in the correspondence memo in the meeting pack, or if there's any items someone wants to raise? No? Okay. Agenda item number 10 is Forward Work Programme. 10.1, Committee's Draft Forward Work Programme. Can I inform members that latest draft of the Committee's Forward Work Programme can be found at pages 307 to 317 of the meeting pack. Can I remind members that the committee indicated last week that the preferred time for a concurrent meeting with the Executive Office Committee on the Police Ombudsman's report on the abusive position for sexual purposes by PSNI officers would be a Tuesday morning. Witnesses are available on the morning of Tuesday the 2nd of June. So can I ask members if they're content for the meeting to be arranged for the 2nd of June? We're all scurrying to look at our diaries, aren't we? What's members' thoughts?
Can you repeat that again? Apologies. Just to get my
Sorry,
diary up.
2nd of June for the joint meeting with the
And what time?
Executive Office.
Are we planning it to start?
Half
Earlier the
9,
better.
I'm gonna say.
Probably 9:30, yeah.
Aye.
I mean, it sits now on the 1st of June at meetings, so there's like...
Yeah.
I'm clear. That's the only thing that's in my diary. So
2nd of June, isn't it?
2nd of June. So I suggest we go
9:30.
9:30. Okay, members content then to go for that? Yeah. Can I inform members that an information event with the Northern Ireland Judicial Appointments Commission, NIJAC, and the Executive Office Committee has also been scheduled for lunchtime on 2nd of June. The Executive Office Committee has indicated a preference to postpone that event, considering we were meeting together in the morning. So can I ask members if they're content to postpone that event until a later date?
Yeah.
And then can I seek members' agreement to note the latest draft of the committee's forward work programme? Agreed? Agenda item number 11, chairperson's business. Can I advise members that I have no chairperson's business this week. And agenda item number 12 then is any other business. Does any member want to raise any other business? If not, then we'll move on. Agenda item 13, date, time and place of next meeting. Can I advise members that the next meeting will take place on Thursday, the 7th of May 2026 at 2 p.m. in room 30 Parliament Buildings. I adjourn the meeting.